Lord, the division bench said, Mr. Rupra, why you are bothered? They are required to give they are having the burden of proving that they have completed 5 years. Why you? That is the language. We can read the language. My learned friend has been kind enough to file that. 9/21 is annexure P5 and 12/11/21 is annexure P26, P6, my lord. In that, my lord, I had argued.
Let's have that P5.
P5 to single bench ka order tha. I was aggrieved. So I went to the division bench. So what the division bench said, my lord? Para 6, my lord, I will read the division bench judgment, page number 157A. The question of granting an opportunity to the writ petitioners is circumscribed by the fact that necessary certificate for 5 years as on 18/11 and also other necessary documents relating to the fulfillment of other conditions are required to be produced by the writ petitioners in terms of the said scheme. Therefore, until and unless the petitioners are able to satisfy the respondent corporation with regard to the same, necessarily no benefit could flow to them. Therefore, we are of the view that what has been granted by the learned single judge is firstly that in accordance with the directions of the Supreme Court, वही 18/1/2011, but also that an additional opportunity has been given. Chalo koi baat nahi. That while granting such opportunity, none of the qualifications have been diluted by the learned single. The requirement of furnishing certificate of working for 5 years as on 18/11 has remained intact. And insofar as producing the other relevant documents is concerned, none of the qualifications as prescribed therein have been diluted by the learned single judge. At the most, it could be said that one more opportunity has been granted to the petition. Therefore, we are of the view no lieu. Now, my lord, what 17240, which I have filed, my lord may just have a look at it, because why to visit? I'm saying my humble submission is that 17420 is correctly decided. But in case my learned friend is aggrieved, my learned friend is free to assist the division bench in the adjudication of the writ appeal, in which also I'll be appearing for the respondent. Lord, please see page number, this return which I gave to my lord, page number 25. I'm giving such like NITs all over Madhya Pradesh, my lord. Just like annexure P1 in the present case, I'm giving such like NITs all over Madhya Pradesh. Same issue was involved. Please see page number, my humble request. My invite, my lord,
Yes,
page 25. This honorable court be pleased to quash the impugned information, white emails dated so-and-so, and further in persons to that tender bids issued in Bhopal, Jabalpur, Indore division also be quashed. Secondly, alternatively, the respondents may kindly be also directed to continue services of members of petitioner till their age of superannuation, and also give them status of permanent employee in regular pay scale like other permanent employees of the department, and any other relief. Now, my lord, all those DB, Anil Kumar, everything has been examined. We can just see. It is the case of the petitioner that the Petitioner Association is a registered association under Trade Union Act. In the name of Madhya Pradesh Petitioner Union were working as temporary peons, sweepers in various offices and branches of MP. The respondents had given the benefit of ESI to the members of the Petitioner Union working in the division of Indore, Bhopal, Gwalior, Shahdol, Jabalpur, Satna. Now the respondents have issued advertisements in Bhopal for appointment of casual laborers through contractors or agencies for Bhopal, Jabalpur, Indore division, and direction has been given to all SOS of branches and satellite branches through email dated 13/6/22 to stop allotment of work of sweeping, cleaning through temporary employees from 15/6/2022, and the said work should be got done through outsourcing, and the members of the petitioner union are being pressurized to fill the forms of contract outsource agency, otherwise the services may be terminated. It is the case of the petitioner that the respondents are trying to adopt the unfair labor practice with members of the petitioner union. The members of the petitioner union are continuously working for more than 15, 25, 35 years of years, sab jhoot hai sir. But not have been granted temporary status, also have not been given the benefit of basic pay along with the allowances payable to the temporary employees, which have already been given to the similarly situated in other states. The members of the petitioner union have also been absorbed in permanent posts, and they have also been given the status of permanent employees just to deprive them from the benefit of permanency. Per contra, petition is vehemently opposed by Council for State. मेरे द्वारा की गई थी. Specific objection has been raised by the petitioner is guilty of malicious concealment of vital facts regarding judgment dated 9/8/21 passed in bunch of so many writ petitions, and also concealment of the writ appeal का order dated 12/11/21 जो मैंने आपको रेफर किया. It is the case of the respondents that crux of the two judgments is that the cases of petitioners were considered for regularization by processing their case. The competent authority was directed to give an opportunity to these with daily wages to furnish necessary certificate of having worked for more than 5 years as on the cutoff date of 18/11, typing mistake. This was to be done by the respondents in the light of the order dated 18/1/11 passed by the Supreme Court in DV Anil Kumar. It is submitted that on the basis of this judgment, scheme dated 20/5/11 was framed. By the order dated 9/8/21, 14 writ petitions were disposed of, and relief was granted to those petitioners only who worked for a period of more than 5 years as of cutoff on 18/11. The order dated 12/11/21 arises out of only one of the writ petitions in which the number of petitioners are 391. The LIC has also filed writ petitions, writ appeals which were decided by judgment dated 28/2/22 passed in so and so in the same as 12/11 wali judgment hui hai. The respondents left no stone unturned to process the case of daily wages. The task was Herculean and a lot of deliberations was required. In spite of that, best efforts on the part of the respondents, the number of cases arising out of various petitions was to be scrutinized, running into many hundred. All the cases could not be disposed of. The processing of cases was to be done as per the order dated 9/8/21 within a period of 3 months. The division bench was kind enough to grant further extension of 6 months. The said extension of 6 months was available only to 391 employees. उसके बाद मैंने सबके लिए ले लिया for extension of time. The MCC was also allowed. The case of all daily wages are being processed as per the order passed by a single bench in WP number 6247 within the time extended by division bench along with clarification granted by DB. All the cases will be considered on the anvil of the judgment passed in DV Anil Kumar and the scheme dated 20/5/11. The writ appeals of the remaining daily wages have been decided on 28/2/22 and the process of scrutiny is on the way. The candidature of each and every petitioner is being scrutinized for their eligibility for considering the regularization but absorption on the basis of documents submitted by the petitioners and also the documents available with the respondents. The petitioners have claimed the relief that they are entitled to continue in service till the age of superannuation and are also entitled for the status of permanent employees in regular case like other employees. The petitioner is also agreed by the opinion dated 13/6/22 by which respondents are issuing tenders for sweepers, drivers, etc. The majority of the members of petitioner union were also candidates who had applied in the year 2011 for regularization as per the terms of the agreement set out in DV Anil Kumar. Their candidature was then rejected for non-eligibility. They filed various petitions challenging their rejection. During pendency of those petitions, the respondents did not take any coercive steps against the petitioner. The applications of the members of the petitioner union have been rejected. Thus, it is submitted by the counsel for the respondents that the petitioner is guilty of suppressing fact so and so. Faced with such a situation, counsel for petition submitted that as far as relief number 2 is concerned, the petitioner is not entitled for the same, therefore he will not press the same. Relief number 2 they are not pressing. That is
regularization.
They alternately respondent may be directed to continue so and so. Regularization की relief press नहीं करी इनकी union ने, which was having hundreds of employees. However, as far as relief number 1 is concerned, it is submitted that a coordinate bench of this court in WP number so and so has observed that one temporary employee cannot be substituted by another temporary. Therefore, if these petitioners are temporary, then they cannot be substituted by other temporary employees. Therefore, it is submitted that outsourcing of sweepers, etc. is bad in law. In view of the observations made by the coordinate bench of this court in WP 6247/18 heard learned counsel for the parties so and so. Now, para 12, whether the respondents can employ sweepers, etc. through outsourced agency or not, and whether it would amount to change of service conditions of petitioner or not, is no more res integra. First ruling relied upon is Hariom. Hariom is also there at page number 44. Entire Hariom is reproduced, not. It's a long judgment. Entire judgment is reproduced. I have also filed copy of Hariom, in which, Lord, that Uma Devi is referred from page number 33. Uma Devi is referred. And then finally, Hariom is decided. That is at page number 42. पेज नंबर 42 में बीच वाला पैरा thus से प्रारंभ होता. My lord has got that. Thus, the petitioners cannot claim that once they have been given appointment on contractual basis for a period of 1 year and the said contractual appointment was renewed either by written order or by verbal order, therefore they are entitled to continue in the said capacity till they attain the age of superannuation. Further, the respondents have taken care of the interests of the existing support staff and therefore in the impugned order 13.8.919 it has been directed that preference would be given to existing employees. So far as the interim orders passed by other council, petitioner cannot point out any. Chalo, आखिरी में. Accordingly, this court is of the opinion that since the petitioners have failed to establish any right to continue to work on contractual basis or regularization, therefore it is incorrect to say that by taking a decision to outsource the employment of support staff, the respondent number 2 has changed the service condition of the petitioner. है ना? It is dismissed. फिर पैरा 14 में मेरा इनका केस dismiss हो गया. In the present case, the claim of the petitioners union for regularization of their services has already been rejected. It is not the case that where respondents are substituting the members of petitioner union by similar employees, but now the employer is being changed and it has been decided that the services of sweepers etc. shall be outsourced. Therefore, it is dismissed. Against this, they have filed 2 months ago, they have filed the writ appeal. Lord, that writ appeal is still pending.
I will consider later part of the day for orders.
Pardon?
Orders later part of the day.
और मैं थोड़ा आपको जजमेंट साइट कर दूं सर. My lord, as I have rightly submitted, my lord, my prayer is twofold in this petition.
अच्छा, एक चीज और सर, there are number of writ petitions pending in this High Court in which not similar like rejection orders have been challenged. But in none, only 2 of these petitions, Lord, they have claimed that I can't outsource. One petition has been dismissed, the other petition is this one. And the other cases, Lord, in which they have challenged the decision which I have taken after processing the cases are these. मेरा कहना है सब एक साथ कनेक्ट करके या तो dispose of कर दी जाए, और if my learned friend wants to argue against outsourcing, he should assess the division bench. मैं आपको रेट अपील करना.
These are fixed for.
Now, return is filed in most of these cases. My contention is सब एक साथ connect करके आप इनके as far as P7 is.
Any date is fixed in these cases?
No. January, February, like that. Various dates. These are those cases in which they have challenged those orders, my lord, in which I have taken a decision that you have not completed 5 years as per DV Anil Kumar, so you are not entitled to regularization.
Yes.
और ये रेट अपील का नंबर मैं आपको दे रहा हूं, आप उसमें इफ यू वांट यू कैन, इफ यू डोंट वांट यू कांट रेजिस्ट. अंगद yes, that is हो गया, बैठ जाओ. And that is writ appeal page number 18 I have made averment. Writ appeal 1452/23. I will not oppose if my learned friend's appearance in the writ appeal, I will not oppose.
Grateful for your advice, but why should I go to writ appeal? I am in a writ petition court. My lords, में please है लोग. सर एक कुछ चीजें जो इन्होंने बताई है, सबसे पहले सर मैं ये क्लियर कर दूं, we are not a party to the writ petition which has been dismissed. We are not the member of that, my lord, association, firstly. Secondly, my lords, please notice, my friend has fortunately he has read that part. The petition which was filed, my lords, please have a relief. What relief they had claimed in that writ petition? Page 25 पर इनके reply के page 25 पर वो relief quote किया है. And my lords, may kindly also notice that they were the sweepers and drivers. None of, my lord, because sweepers have never been kept as a temporary employees, they have always been engaged on contract basis for limited period. So their case was entirely on a different footing. None of the sweeper is a party in this writ petition before your lords. So that case was absolutely by a different category of persons. Now please see the relief. This honorable court may please to quash the impugned information issued wide email dated 13/6/2022 and further in pursuance to the tender bids issued in Bhopal, Jabalpur, Indore division also be quashed. Alternatively, the respondents may kindly also be directed to continue services of the members of the petitioner until their age of superannuation. A very entirely distinct prayer is made. Without saying anything, they say we should be allowed to continue till we attain the age of superannuation. They do not claim permanency. They do not say anything. They only say कि superannuation तक आप हमको रखिए. दूसरा सर ये जो अनेक्चर P7 चैलेंज किया 13/6/22 का, वो 22 की पिटीशन में मेरा ये जो अभी मैंने चैलेंज किया NIT, this NIT is of 2023. It cannot be a subject matter of the writ petition filed in 2022. How that can be said to be the same issue? Then my lords may please see, इन्होंने खुद उस बेंच के सामने कहा कि हमने इनके केसेस अंडर स्क्रूटनी है, उसमें भी इन्होंने कहा. My lords may please have a look. उसमें पैराग्राफ 4 में भी kindly seen for a minute. Those petitioners even my lord admitted that they are not the temporary employees also. हम लोग टेम्पररी हैं, इसमें कोई डिनाइल नहीं है. ये भी डिनाई नहीं करते कि हम टेम्पररी एम्प्लॉइज हैं. और पैराग्राफ 4 देखें सर काइंडली. इट इज द केस ऑफ द पिटिशनर्स दैट द रिस्पोंडेंट्स आर ट्राइंग टू अडॉप्ट द अनफेयर लेबर प्रैक्टिस विद मेंबर्स ऑफ पिटिशनर यूनियन. Members of petitioner union are continuously working for more than 15, 20, 25 and 30 years but have not been granted temporary status and have also not been given the benefit of the basic scale along with allowances payable to temporary employees. वो कहते हैं टेम्पररी एम्प्लॉइज का स्टेटस भी हमको नहीं दे रहे हैं. दे राइटली सेड बिकॉज स्वीपर्स हैव नेवर बीन गिवन द स्टेटस ऑफ टेम्पररी एम्प्लॉय. Whereas in our case, the entire case of theirs and ours is that we are temporary employees and they say that we do not meet the criteria to get regularized as per the criteria fixed by them. So where is the question of Manor that the similar issue has been considered? They were even not temporary employees. Now they abandoned their claim of regularization. That makes entire distinguishing feature in this case. They claim, my lords, may please see paragraph. Court has noted that they have relinquished, my lords, may please have a look on page 29, paragraph 8. Page 29. They say, faced with such a situation, counsel for petitioner submitted that so far as relief number 2, that is regularization, is considered, the petitioner is not entitled for the same, therefore he will not press the same. उनका और हमारा केस एक जैसे हो कैसे सकता है? मेरा तो पूरा क्लेम ही रेगुलराइजेशन का. Then, my lords, they made a statement before the court. Kindly see paragraph 7. They are trying to hoodwink the court. Paragraph 7 देखिए सर. Paragraph 7 में the court has noted on their submissions, my lord. By order dated 9/8/2021, total 14 writ petitions were disposed of and relief was granted to those petitioners only who worked for a period of more than 5 years as on cutoff date 18/1/2011. The order dated 12/11/2021 arises out of only one of the writ petition in which number of petitioners was 391. LIC had also filed writ appeals which were decided by judgment dated so and so, so and so, so and so. The respondents left no stone unturned to process the cases of daily wages. The task was Herculean and lot of deliberations was required. In spite of best efforts on the part of the respondent, the number of cases arising out of various petitions was to be scrutinized, running into many hundreds, and all cases could not be disposed of. ये इनका स्टेटमेंट है, all cases could not be disposed of because this is a Herculean task and we are undertaking that process. The processing of cases was to be done as per the order dated 9/8/2021 within a period of 3 months. The division bench was kind enough to grant further 6 months extension. The said extension of 6 months was applicable to only 391 petitioners. The respondent thereafter filed MCC number so and so for further extension of time. The MCC was allowed by order dated 5/7/2022 and a further time of 4 months was granted by the division bench. The cases of all daily wages are being processed as per the order passed by the single bench in writ petition number so and so within time extended division bench along with clarification granted by the division bench. उसमें भी ये कह रहे हैं कि the cases are still under consideration. We are examining those cases. Then all these cases will be considered. Now please see, all the cases will be considered on the anvil of judgment passed in case so and so, scheme dated so and so. The writ appeals of the remaining daily wages have been decided by us and the process of scrutiny is on the way. How can they say, they themselves are saying हम scrutiny, आप कहते हैं हम तो 7 लोगों का कंसीडर कर रहे हैं. कंटेम्प में ये कहते हैं इसका मेहमत एक्सरसाइज. यहाँ कह रहे हैं 7 लोगों का था. अगर 7 लोगों का मेहमत एक्सरसाइज तो नहीं हो सकता. The court has noted that they said that it's a mammoth exercise and on their request court granted them 3 months time. Where is the question of mammoth exercise for the 7 persons? At least this hoodwinking of the court should not be done. इन्होंने एक रिप्लाई फाइल किया है सर. ये इस रिप्लाई में मैंने अपनी रिट पिटीशन में बहुत स्पेसिफिक प्ली लिया है सर कि ये पेमेंट जो करते हैं सर, मैं क्या डॉक्यूमेंट प्रोड्यूस करता हूँ. काइंडली कंसीडर दिस एस्पेक्ट. व्हाट डॉक्यूमेंट आई कैन प्रोड्यूस when I am engaged, they made me payment. Earlier the cash payments were being made. 2011 के बाद में अब पेमेंट जो है अकाउंट में आता है. नाउ वी कैन शो दी अकाउंट. पहले पेमेंट कैश होता था. ये पेमेंट वाउचर में क्या करते हैं, हर 2 साल में एक आदमी को चेंज कर देते हैं. हर 2 महीने में ये सर क्या करते हैं, मेरा नाम अगर सुरेश है, अगले महीने में मेरा नाम दिनेश कर देंगे. पेमेंट मैं ही लूंगा, सिग्नेचर मेरे ही है, लेकिन वहां सुरेश का दिनेश कर देंगे. मैंने स्पेसिफिकली कहा है. दे हैव नॉट रिप्लाइड टू दैट. ये इन्होंने सर इतना बड़ा रिप्लाई फाइल किया 83 पेजेस का. दे हैव नॉट सेड इन अ सिंगल लाइन कि मेरा ये कंटेंशन झूठा है, आई एम लायबल टू बी प्रोसिक्यूटेड फॉर दैट. दे हैव नॉट सेड. एंड इफ आई कैन ड्रॉ द अटेंशन ऑफ लॉर्डशिप माय प्ली इन द रिट पिटीशन, आई हैव वेरी कैटेगोरिकली सेड दैट दिस टाइप ऑफ फ्रॉड इज बीइंग प्लेड बाय देम. प्लीज हैव अ लुक पैरा 5.14. आई एम सेइंग दिस ऑन ओथ. 5.14. I have said it is respectfully submitted that petitioners are working with respondents for 10 to 20 years and they are fully eligible for regularization as per the scheme framed by respondent number 1, which was a part of affidavit before the Honorable Apex Court. Prior to the year 2011, the payment to the petitioners were made in cash and documents relating to payments are available with respondent, which is a mode to demonstrate the length of service of the person with respondent. It is, however, pertinent to mention that in order to deprive the petitioners and similarly situated employees of the benefit of prolonged spell of service as temporary employees, the respondents have been resorting to illegal and unethical practice. In the pay bills payment slip, the name of employees are changed in every 2 months and the payment was released in different names to hide the actual length of service of an employee. This practice was prevalent throughout the country. After 2011, the payment is now directly made through bank account. If the respondents are permitted to hire the manpower through outsourcing, the petitioner will be seriously perjured. So this type of practice is being followed by them. And there is no reply to this. Now, my lords, may please see what is the law. Can my lord ignore the law? The law as on today, my lord, by the Supreme Court is that an ad hoc employee, a temporary employee, a contractual employee cannot be replaced by another set of contract ad hoc or temporary employee. And all over the country, I have searched for the judgment, my lord. There are, my lord, at least 25 high courts who have spoken on the subject, and they have said a contract employee or a temporary employee cannot be replaced by another set of temporary employee. Now here, my lord, assuming for a minute that they want to dispense with the services of the temporary employees and replace it by way of the outsourcing. It is a policy decision. They have filed the reply. In this reply, not even a single line has been uttered as to when this policy, Life Insurance Corporation of India is a government of India undertaking. They cannot take any decision at their own. They have not said even a single line that we have taken a policy decision to replace this and here is the policy decision. But Allahabad High Court has dealt with that aspect elaborately. My lords may kindly see, this is one thing to say that we want to hire the person through outsourcing. The another thing is that now there is a prohibition to employ the person through direct contract. They have not come out with a case that now there is a prohibition. We cannot keep these directly contracted employees because now we have taken a policy decision to hire the person through outsourcing. There is no such plea. In absence of that, my lord, we are not, my lords, I may make it very clear. We are not against the outsourcing. It is their prerogative. If they want to have the outsourcing, they can have outsourcing. We are not averse to that. But we are saying you cannot replace it. You outsource. If you need 600 persons and if we are only 300, you employ 300 persons through outsourcing. We have no objection. But you cannot replace all 600 by throwing us out and bring all persons through outsourcing. That difference has to be understood by them. And kindly see in this reply, Not even a single line, they have nowhere said, my lord, our apprehension is correct to approach this honorable court that if they are permitted to employ the person through outsourcing, they are going to do away with our services. They have not said even a single line, my lord, in this order, in this reply, that no, our apprehension is incorrect. They are not going to throw us out. Meaning thereby that there is an imminent danger, my lord, even imminent danger is there of our being throwing out. Therefore, my lord, at the moment, we are praying only that because regularization issue will be decided later on. The question would be, my lord, that though we have said that this NIT may be stayed, we are, my lord, not interested in staying the NIT. We only seek the protection that till, my lord, this matter is decided, a status quo with regard to our service conditions. We are not asking even an increase of 1 rupee in our present salary, my lord. We are not saying that. After all, we are working for last 20, 30 years. What will they gain if they get some outsourced person, inexperienced persons, in place of experienced persons? But I'll just place 3-4 decisions before your lordship. 2 are, my lord, the Supreme Court decision, where the Supreme Court has said that contractual employee cannot be, my lord, replaced by another set of contractual employee. 2000 ये वाला इनका नहीं किया ना. पर ये 2 जजमेंट का मैं नोट करा देता हूँ. I'll give the photocopies. Rest of the orders are here. But even in a case of guest faculty, Supreme Court said, my lord, in guest faculty, my lord, they have no status. Guest faculty, they just come, my lord, teach one class or one period, and they go away. Supreme Court in this Jan Bhagidari case, my lord, this went from MP only, and in that Supreme Court said that, my lord, I'll just Manish. No, not this one. My lords, may please have a look. This is a judgment. This was a case, my lord, where the persons engaged in, my lord, higher education, they were replaced by another set of guest faculty. My lords may kindly refer to the last page. My lords may kindly refer to last page, paragraph 16. I, my lords, my lord, C1, my lord, the writ petitioners appellant herein would entitle to continue on their respective posts till they are replaced by regularly selected candidates. Because in this, my lord, the grievance was raised that every year they are replaced by a new set of guest faculties. Court said they will not be replaced unless the regular appointments are made. And, my lords, the another decision, this is 2007. This is 2007, volume 13, SCC 292. In this case, paragraph 13, I'll supply a photocopy of this judgment. Here also the Supreme Court says we have carefully looked into the judgment of the High Court and other pleading that have been put forth before this court. It is clear that though appellants may not be entitled to regular appointment as such, it cannot be said that they will not be entitled to minimum of the pay scale, nor they should be continued till regular appointments are made. The course adopted by High Court is to displace one ad hoc arrangement by another ad hoc arrangement, which is not at all appropriate for these persons who have gained experience, which will be more beneficial and useful to colleges concerned rather than to appoint persons afresh on ad hoc basis. This is paragraph 3 of this decision. So here also Supreme Court says, my lord, then my lord, there is another decision, 2003, volume 10, SCC 284. This is also to the same effect that one set of temporary employees should not be replaced by another set of temporary employees. Then, these are 3 decisions of 2 decisions of the Allahabad High Court and Gujarat High Court, where they have considered about this aspect in detail. And they have said, my lord, that there is no gainsaying that once the persons are, they are engaged on temporary basis, they cannot be replaced by another set of temporary employees. So here, my lord, at the moment, by limited period, my lord, in any case, now if we see the balance of convenience also, we are working for them. They are not paying us anything freely. We are working. Therefore, where is the, what should be the worry of the corporation? If the old employees, experienced employees are allowed to work for some more time during pendency of this writ petition, they are not going to suffer anything. It is just एक इनका ego है कि नहीं, आप कोर्ट में चले गए तो हम आपको रहने नहीं दें. And especially in view of the fact that contempt petition, they themselves made the statement in the writ petition which has been decided, which they are relying on. In that writ petition itself, they have said that exercise is undertaken, it's going on. How can they do this? And
Later part of the day, I will.
yes,
see to
I am
it.
grateful.
Lord, I only want to say one thing, Lord. My learned friend has quoted many rulings. Lord, those rulings may be the law, but please see, we can't get out of the Supreme Court order, which is at page number 137, 18/1/2011, which I have been referring, page number 137. We can't get out of this order, Lord. That's the whole problem.
बोल लीजिए उसके बाद I'll clarify that.
Because my learned friend did not cite those citing.
मैंने पढ़ा है ये शुरू में, आपको याद होगा मैंने जजमेंट में से ये पढ़ा है, ये पैरा स्पेसिफिकली ये पैरा पढ़ा मैंने.
नहीं, मैं ये नहीं बोल रहा, मैं बोल रहा जो रूलिंग्स कोट करी ना. So I just want to meet that. My lord will be kind enough to see page number 137, para 6 of the Supreme Court judgment. It is very clear. Such of those temporary employees who do not apply or are not successful shall cease to be in the employment. So my learned friend, Lord, cannot ask this honorable court to sit and appeal over the Supreme Court judgment. I have failed to understand what is the
Paragraph.
page number 137, para number 6. I have to examine the cases, and after examination, क्या होगा? Para 6 में is written, such of those temporary employees who do not apply or are not or not successful shall cease to be in the employment. So, Lord, my learned friend is asking for stay of the Supreme Court case in the High Court.
मैं अभी बताऊं.
मेरे को बोलने दी.
मैं बताता हूँ उसमें क्या है.
मेरे को बोलने दी.
सर ये इसको पढ़ें सर, इस लाइन को काइंडली देखें सर. सुप्रीम कोर्ट ने कहा सच, मैंने ये पहले भी सर शुरू में आर्गुमेंट के शुरू में मैंने ये पढ़ा था. सुप्रीम कोर्ट ने कहा सच ऑफ द एम्प्लॉई हु डू नॉट अप्लाई और दोज हु अप्लाई बट दे फेल. इन्होंने तो हमको एग्जाम में बैठने ही नहीं दिया, हम फेल कहाँ हुए? इन्होंने तो हमारा कैंडिडेचर रिजेक्ट कर दिया सर. ना तो हम उन कैंडिडेट्स में हैं जिनको कि हमने अप्लाई नहीं किया, हमने अप्लाई किया एडमिटेडली. इन्होंने हमारा हमको एग्जाम में बैठना था, इन्होंने हमारे एग्जाम से पहले हमारा कैंडिडेचर रिजेक्ट कर दिया, तो हम फेल कहाँ हुए? आपने तो प्रोसेस में हिस्सा ही नहीं लेने दिया हमको. हमारा ग्रीवांस यही तो है, और आप भी कहते हो नहीं, आप 5 साल का क्राइटेरिया पूरा नहीं करते इसलिए एग्जाम में नहीं बैठोगे, आप इंटरव्यू में नहीं आओगे. नहीं, कहने सर हमको तो आपने ना तो बैठने दिया ना आपने
नहीं
फेल किया. आप पढ़िए ना जजमेंट को, आप ऐसा मत पढ़िए, जजमेंट को जैसा लिखा है वैसा पढ़िए.
My lord, this annexure P7 is preceded by a detailed application of.
हाँ, बिल्कुल सही बात है.
And Lord, in about 10 writ petitions which I have given number, I have filed reply in most of them. There is no interim relief in any case. There is no interim relief in any of these cases.
सुप्रीम कोर्ट ने सही तो कहा कि अगर ये फेल हो जाते हैं, आप पोस्ट को भरोगे, परमानेंट एम्प्लॉय से इनको कहाँ रखोगे, इनको घर बिठाओ. तो आपने तो हमको हिस्सा ही नहीं लेने दिया.
Later part of the
आई एम ग्रेटफुल.
The matter pertains to grant of promotion, notional promotion at par with the other juniors. We have moved an application for final hearing at motion stage. May kindly grant any date and week commencing January for listing the matter in motion stage for final hearing.
IA number 18948 of 2023 is an application for final hearing of the main case at motion stage. Full stop. Writ petition was admitted. Void order dated 10/3/2006. Then counsel for the applicant submits that the proceedings on record. Now the fact remains that the petitioner has challenged the legality and propriety of order number 1076 dated 14th December 2005, whereby prayer of the petitioner for promotion to E2 grade with effect from 26th May 1993 and E3 grade from 31st January 1997 at par with his batchmates has been rejected. Petitioner is going to be superannuated in the month of May 2025 and therefore early disposal of this writ petition becomes a necessity. So in view of the controversy involved in this present case, any objection, madam?
No, madam.
The counsel appearing on behalf of respondent has no objection to the aforesaid application. In view of facts and circumstances of the case, I deem it appropriate to accept this application and direct that the present case be listed for final disposal in the recommencing February.
Obliged.
This case twice it has been admitted for final hearing in the due course, my lord.
Lord, I have made application for final hearing. The motion is still on the ground, Lord, that two of the petitioners have already retired and the person who is surviving is still in service, is also left for retirement within a short period. Now, Lord, the issue is very short. What should be the criteria?
26th April 2022 order. This was directed to be listed for final hearing as per seniority and turn in part B. Where it is listed now in part B?
Oh, it has come up before the Lordship on the basis of my application, Lord. IA number.
It was never listed earlier to that.
I'm sorry, because that order sheet will reflect.
Because on twice this order, first order was on 8th August 2016. List this matter for final hearing in due course on its own number. The second order came to be passed on 26th April 2022. Whether those orders can be ignored.
Or those, since the orders are already by the Honorable Court, Lord, I don't say that they are to be ignored. But my contention before Lordship is, Lord, that 3 out of the 4 persons, not 3 have already reached the.
That contention was very much available on 26th April 2022. Recently that order was passed. Just 1 year ago, about 1 year ago.
Lord, since
1.5 years.
1 year has passed, Lord, your Lordship may kindly consider my prayer because only one person has left in service now. And he is also due for retirement just within a period of 6 months.
IA number 17072 of 2023 is an application for final disposal of the main case at motion stage. The counsel for the petitioner, some applicant petitioner submits that more than 1.5 years, the time of more than 1.5 years has lapsed from the last order passed by this court, directing the listing of this case as per seniority and turned in part B of the cause list. Full stop. Out of how many petitioners?
No, 4.
Out of 4.
We have
petitioners,
already reached the age of
3
superannuation.
petitioners have already retired on attaining the age of 60 years. Only one petitioner is left, and he too will retire on
Within a period of 6 months.
within a period of 6 months. In view of the aforesaid status of the case, the counsel for the applicant submits that this case be heard at motion hearing stage on some early actual date. Yes, any objection, Mr. Sahu?
Any date may be fixed, Madam.
Any objection?
No objection.
The state council has no objection to the prayer made by counsel for the petitioner. In view of aforesaid factual condition, the application is allowed. The case is directed to be listed for final disposal. Week commencing
Not if it is
February.
will be taken in the month of January.
January is full.
Or last week, maybe kindly.
Last week of January.
No, I'm obliged.
Same order in connected case.
Not connected case.
We
Some
heard
other council is appealing, but it's same order.
We heard with.
Yeah.
Your Lordship, kindly list this matter after vacation, Your Lordship.
On request adjourned.
Anubhuti Lakhera. I'm a proxy counsel in this case, Your Lordship. Anubhuti Lakhera. मैं लिख कर दे देती हूँ.
Lordship, petitioner has already been superannuated from the services with effect from 28/4/2017 from the post of additional director, Your Lordship. Your Lordship, when petitioner was transferred at CD in the year of 2006, there was some corruption was made by the officials, Your Lordship. And due to that, Your Lordship, after retirement, the petitioner has not been given any retirement dues. He is getting only 90% pension, and gratuity and leave encashment has been withheld by the respondent. On the basis of there is an inquiry is pending before the EOW, Your Lordship. And that
What's
corruption.
the stage of that inquiry, whether challan has been presented?
No, even Your Lordship, my name is not included in the FIR. This is the letter issued by the Lordship, may kindly see by the EOW.
What is the FIR? FIR is for the corruption charges. And you are not accused in
I am not accused. The corruption was made before the posting of the petitioner
by whom?
by the officials, Your Lordship. May kindly see, Your Lordship, page number.
What is the stage of that investigation? Challan presented?
No, Your Lordship.
Report under section
Investigation
170
is
presented?
going on. Investigation is going on. May kindly see the page number 2, Your Lordship.
You were arrested?
No, nothing. My name is not there, Your Lordship. So since 2006.
That petitioner is not named in the FIR. Investigation in the aforesaid criminal case is still pending, still going on. Petitioner has not been arrested nor subjected to interrogation in any manner. Petitioner stands retired.
28/4/2017.
The court has not taken cognizance of the offence so far. Retirement dues of the petitioner have been stalled. Issue notice.
नहीं, week तक.
Mr. Sahu accepts notice on behalf of all the respondents
1 into 9.
and seeks time to file reply.
Any week.
After 4 weeks, Madam.
4 weeks.
Okay.
Also, this petition is claiming the petitioner also the family pension also.
Family pension
Not sir. The
in
petitioner
favor of
submit-
daughter,
Not sir.
unmarried daughter.
Not sir. A mental disability have no.
contends that the petitioner seeks grant of dependency pension after the demise of her parents. Father of the petitioner is aged. Petitioner is unmarried. Daughter of Munna Lal Tiwari, who was employed as stenographer in the office of Collector Patna. Patni. Full stop. Father of the petitioner was getting family pension? How family pension? Of mother?
No, not sir. Father and mother dependent, the petitioner dependent, not say fathers.
Your father was a pensioner or father got family pension after the demise of your mother?
Not sir. Fathers.
Father was getting pension. He was the government servant, my lord.
That not. दोनों mothers and father के ऊपर
Why you have mentioned father was getting family pension? He was getting regular pension.
not sir. Not.
So you are trying to confuse the issue total. Family pension is in case your mother was a pensioner and after the demise of mother, spouse gets family pension.
She is not.
Your part, you are just confusing the issue. Father of the petitioner was a pensioner. Petitioner and her mother were solely dependent upon the pension of her father. Mother of the petitioner also died on 25th January 2020. Father of the petitioner has died on 10/9/2000. Even date you have,
2022.
where you have mentioned
As per his representation note.
2022. You are disabled.
Not sir. Mental disorder.
Petitioner is a disabled person having retardation. What is ailment with which you are suffering from?
Not a 25 mental disability. Not sir.
Having 25% mental disability. That has been verified by with the help of medical certificate.
Not sir. All those are documents will submit the respondent.
Issue notice returnable on such and such date.
No.
लॉर्ड तो पिटीशन विड्रॉ करना चाहते हैं विद लिबर्टी पिटीशन विड्रॉ करना चाहते
Petitioner
विड्रॉ करना चाहते हैं सर
withdraw.
जी विद लिबर्टी के साथ फ्रेश पिटीशन फाइल करना
फिर क्या करेंगे?
इसमें सर कुछ तथ्य छूटे हुए थे
तथ्य छूट गए कहां पर?
पिटीशन में से
आप भूल गए क्या? कहीं रख के भूल गए तथ्य को?
नहीं सर लॉर्ड से पिटीशन दोबारा से न्यू पिटीशन लगाएंगे
At the very outset, counsel for the petitioner
दीप चंद
seeks to withdraw this writ petition with the liberty to file fresh writ petition with better particulars. Dismiss as withdrawn with the liberty aforesaid.
The respondent is the son of the petitioner. The petitioner purchased the suit property in his name and in the name of his son, respondent number 1, when he was minor at age of about
Let's
2
see civil court decree passed.
Civil court degree passed that it is the joint Hindu family property and ancestral property. Therefore, the petitioner, respondent, and other son and daughters of the petitioner are owners of the property.
That civil court decree was in your favor.
Yeah, no, first appeal court. First appellate court. I have filed copy and excerpt P2. P2.
The first appellate court also upheld the decree of the trial court.
Decree of the trial court, it is held that it is the joint Hindu family property of the petitioner,
Suit was filed by
filed by the petitioner.
so you filed suit for declaration.
Declaration that I am the exclusive owner.
You are an exclusive owner of
Huh.
the property in question.
Huh.
Then suit was
Dismissed.
dismissed, and you were not found to be exclusive owner of
Exclusive
the
owner.
property.
The
Rather,
appellate
your
court
son-
held it is the joint Hindu family property of the petitioner and defendant.
and your son.
So my submission that when it is the ancestral property of the petitioner and it is held that this is the joint family property of the petitioner and defendant, therefore all the sons and daughters are the co-owners of the property.
That was not the declaration sought by you.
जी
Your declaration sought by you
नहीं,
was
नहीं,
that you are exclusive
declaration-
owner in possession.
नहीं वो तो ये तो होल्ड कर दिया ना कि it is the joint Hindu family property.
Yes.
So my submission the revenue court held that petitioner and defendant are the owner of the property and divided the property in between two. And my submission that when it is the ancestral property, the petitioner, defendant, other sons and daughters are equally entitled.
So partition, all should be read as parties.
हाँ, yeah. और तहसीलदार 178 में दो लोगों को
So
भी
your share will be substantially reduced then.
reduced.
For that you will have to see the decree. What was the decree granted by the trial court?
ट्रायल कोर्ट की डिग्री तो हमारे फेवर में नहीं थी. अपीलेट कोर्ट हम तो कह रहे थे हम एक्सक्लूसिव ओनर है,
आपकी बात नहीं मानी.
नहीं मानी. अपील कोर्ट ने कह दिया.
Whether it was held that the property is ancestral in nature.
हाँ, यस. अपीलेट कोर्ट का
Let's see the decree.
ये डिफेंडेंट ने भी कहा है. डिफेंडेंट ने भी कहा कि ग्रैंडफादर के से खरीद.
Sir, अब let's read the decree.
डिग्री देखें सर. एलेक्जर P2 पेज 27 से इसका ये देखें. इसको फाइंडिंग जो है लास्ट पैरा पेज 33 में कंक्लूजन यह घोषित किया जाए विवादित भूमि खसम और सोच तो
Page 30.
पेज 33 पैरा 18 यह घोषित किया जाता है विवादित भूमि खसम और सोच तो राज मऊ तहसील एवं वादियों प्रतिवादित में एक की पैतृक संपत्ति होकर उनके संयुक्त स्वामित्व आधिपत्य की है.
So what is the composition of the family?
हमें हमारा ये लड़के हैं, बाकी और दूसरे लड़कियां हैं.
Contents that White Civil Court decree dated
ठीक
19th January 2019. What is the date of the judgment and decree?
17/19 17/2019
1/7/2019. Passed by
एडिशनल डिस्ट्रिक्ट जज गोहर.
the trial court decree.
ट्रायल कोर्ट डिक्री तो पहले थी. ट्रायल कोर्ट की डिक्री 19/119
19 the White Civil Court decree dated 19 January 2019. The suit of the plaintiff petitioner was dismissed and the property in question was held to be ancestral property where what is स्वामित्व संयुक्त स्वामित्व
संयुक्त स्वामित्व जी पैतृक संपत्ति होकर संयुक्त स्वामित्व की
ancestral property
जी
where all the stakeholders would be joint owners
जी
of the same. Based on such decree, no defined share can be presumed in favor of the respondent number 1
जी
and the entitlement of each of the contesting parties will be substantially reduced in view of composition of the family. The partition was to the extent of 50% ordered.
उन्होंने 50% कर दिया, 50% इसका, 50% पिटिशनर का, दोनों का, बाकी लड़के
As if there is no other person who will succeed the property.
उसमें माने नहीं, तहसीलदार ने कह दिया बस वो तो हम दो ही का मान रहे हैं.
Full stop. Apportioning the whole land between the plaintiff and respondent number one would be wholly illegal. As other owners would also stake their entitlement in the joint family, in the joint ancestral property, in the joint ancestral property. Issue notice. Now, what is the status of partition? Any sanat taqsim granted?
नहीं, अभी तो ज्वाइंटली अभी कर रहे हैं, एग्रीकल्चर कर रहे हैं, वो उसके थर्ड पार्टी इंटरेस्ट क्रिएट न करें, स्टेटस को भी मेंटेन बस और क्या.
Till the next date of hearing, there shall be status quo regarding alienation of the
Yes.
fruit property.
इस मैटर लॉर्डशिप अभी नोटिस नहीं हुई इसमें. लॉर्डशिप respondent file application before the SDO lordship under section 250 MPLRC lordship. इसमें बेदखली के लिए इन्होंने एप्लीकेशन मूव किया मैंने. उस पे 15/3/2000 27/6/2015 को एसडीओ ने तहसीलदार को डायरेक्ट किया कि आप इसकी इंक्वायरी करके और प्रॉपर देख लीजिए. उस ऑर्डर के कंप्लायंस में लॉर्ड काइंडली सी एनेक्जर P2 पेज नंबर 14 लॉर्डशिप 3/1/2017 का ऑर्डर. इन्होंने एसडीओ के ऑर्डर के कंप्लायंस में फ्रेश ऑर्डर पास किया लॉर्डशिप कि इनको 1 फीट जो इनका मकान बना हुआ है उसको हटाया जाए लॉर्डशिप. ऑर्डर अगेंस्ट फाइल लॉर्डशिप अपील बिफोर द एसडीओ लॉर्डशिप सेक्शन 44(1) लॉर्डशिप. एसडीओ ने अपील को डिसमिस कर दिया. उस ऑर्डर के अगेंस्ट में मैं कमिश्नर के यहाँ गया, कमिश्नर ने भी हमारी अपील को डिसमिस कर दिया. ऑर्डर अगेंस्ट मिसलेनियस पिटीशन में लॉर्डशिप. इन्होंने एक पॉइंट को पकड़ के रखा है कि जो पटवारी ने प्रतिवेदन दिया है वो प्रतिवेदन सही है, उसी के आधार पे इनको डिस्पोजेस्ट किया जाए लॉर्डशिप. बट पटवारी का प्रतिवेदन गलत है, उस पर हमने ऑब्जेक्शन लिया है लॉर्डशिप. ये आउट ऑफ लिमिटेशन है लॉर्डशिप. इन द ईयर लॉर्डशिप 1988 में ऑलरेडी एसडीओ खड़ा होकर के और इस मकान का निर्माण करवाया माय लॉर्ड. और इन्होंने 2016 और 17 में तहसीलदार के यहाँ एप्लीकेशन बुक किया आफ्टर 16-17 ईयर लॉर्डशिप.
किस प्रोविजन में एप्लीकेशन दी है?
150 लॉर्डशिप एमपीएलआरसी में माय लॉर्ड.
250 और 150?
सॉरी 250 लॉर्डशिप.
250. Read 250.
माय लॉर्ड.
Whether 250 is in respect of गैर मुमकिन मकान और it relates to agricultural land only.
माय लॉर्ड.
Where house is constructed, nature of land will be changed to agriculture to गैर मुमकिन.
No my lord, मुमकिन लॉर्डशिप.
I am saying something in your favor. You said no.
Yes lord.
When house is constructed over the land, the nature of land will become
agriculture lordship.
Agriculture.
Yes lordship. Personal land है मेरी my lord.
When house is constructed over some portion, that land become agriculture.
Yes, personal land lordship. Non-agriculture lordship.
Non-agriculture.
My lord.
And further it will be termed as गैर मुमकिन मकानात.
Yes.
It will be shown like this in the criminal record.
Only पटवारी प्रतिवेदन lordship.
What is प्रतिवेदन पटवारी?
After inquiry lordship.
Let's see 250 first.
My lord.
That is restoration of possession.
Yes,
from
lordship.
where the person has been illegally possessed. How this provision is attracted to your case? Your case is that this alleged encroachment, you have not been dispossessed. So it is restoration reinstatement of Bhumi Swami improperly dispossessed. It is just like 144 CPC restitution. How this provision is applicable?
नो अप्लीकेबल लॉर्डशिप 250 मेंटेनेबल ही नहीं है.
Contends that section 250 of Madhya Pradesh Land Revenue Code 1959 has been resorted to for removal of encroachment of residential house which is not maintainable in view of bare reading of the provision itself. The provision relates to reinstatement of Bhumi Swami improperly dispossessed. The provision is like a restoration of possession in terms of section 144 CPC. 144 CPC. The house of the petitioner is in existence for the last more than 16 to 17 years. Issue notice till the next date of hearing, there shall be status quo regarding possession of the property in question.
Lord, this petition is directed against an impugned order, annexure P4 at page 55, passed under section 24 of the Hindu Marriage Act, awarding interim maintenance at the rate of rupees 15,000 per month.
How much is you are earning?
Lord, the earning lot has been assessed between 90,000 to 1 lakh. Lord, he's a district legal aid officer. Lord, but what has happened, Lord? If a lordship would say P5, the interim maintenance, the maintenance under section 125 has already been granted at the rate of rupees 23,000 per month, which I am paying, which is not under, which has not been challenged. I am already paying. P5, if a lordship would see, is that page.
How much has been awarded under this 24?
24 and 15,000 per month. Usme 23,000 already there.
That is subject to adjustment only.
That would be subject to adjustment, but I am already. But what has happened, Lord? If a lordship would see P4, the impugned order, this has been made applicable from the date of the order, from the date of the application, Lord. Whereas, Lord, under section 125, I am already paying since 20th of September 2020, 23,000.
That much amount has to be additionally paid.
That much amount has to be additionally paid. Then, Lord, one more fact, Lord. Earlier, Lord, an application under section 13B was filed for divorce by mutual consent. Now, Lord, I had agreed for payment of rupees 20 lakhs towards permanent alimony. Out of 20 lakhs, Lord, 4,70,000 has already been paid. Lord.
13B.
13B. Now, what has happened? She subsequently, there was a first motion, Lord, there was a statement of both the parties, which I have brought on record. After 6 months, when both the parties had appeared, husband was ready to pay the remaining amount, but she refused. She resigned, Lord. When she resigned, Lord, that amount she is still retaining, 4,70,000, Lord. And that we have specifically stated our reply to her.
Contents that the respondent wife is already getting an amount of rupees 23,000 per month under section 125 CRPC. Even in a petition under section 13B of Hindu Marriage Act, an amount of rupees 4,70,000. 70,000 was paid at the stage of first motion hearing.
Between first to second motion, it was required to be paid in stages.
After first motion hearing,
yes.
At the stage of second motion, the respondent wife resigned from the compromise, and the aforesaid amount of rupees 4,70,000 is still being kept by this respondent in an unauthorized manner. The present award of rupees 15,000 per month towards litigation, towards maintenance pendant light, has been awarded from the date of application, the date of filing of application. Issue notice Yes, how much litigation expenses you will deposit?
5,000 award ke that I'll deposit.
Who will be engaged for 5,000? You must have charged in lakhs of rupees, and you want her to engage a lawyer
Not,
at
he is a
5,000.
person of a fraternity, district legal aid officer. I'm not difficult to charge anything from them.
Let's be reasonable so that the lawyer who may be engaged may get substantial amount towards fee.
So whatever, we are already paying otherwise 23,000 per month. That is being paid to her. 4,70,000, she is retaining it.
10,000. Issue notice subject to deposit of an amount rupees 10,000 with the registry of this court
Yes.
payable to the respondent on her appearance
Yes.
as litigation expenses.
आइटम नंबर 9 सीसी टुडे लॉर्ड से आइटम नंबर 9 में सीसी टुडे कर दें लॉर्ड से
9.
यस अभी जिसमें हेयरिंग हुई
हाँ. What do you mean CC today?
लॉर्डशिप सर्टिफाइड कॉपी सेम डे में
I will sign the order today itself. आप घर भिजवा दें, कोई बात नहीं है.
Lordship, in this petition, we are seeking direction to the respondent to extend the benefit of regularization. Why our other contemporaries and juniors have been regularized in service. Petitioners were appointed on different posts as monthly wages fixed by collector under the drive to provide job to most backward scheduled tribe. Petitioners were belong to scheduled tribe of Bharia, and petitioners were given.
When you were appointed for the first time?
First time we were appointed on 3/8/1996. I have annexed page number 12, annex P1. 3/8/96.
As
Lordship as Chowkidar and on the post of Chowkidar.
Daily wage employee.
Daily wage employee.
Contents that petitioners were appointed as daily wage employees on 9/8/1996 under a drive to provide job to the most backward scheduled tribe. Full stop.